Welcome to Boundary Wars, where we unpack when quitting without notice might be justified and how to do it without torching your career. First, we will clarify the 2-week notice myth, then explore what to do when your availability is ignored, and finally walk through clear steps to protect the role you value the most. Here is the roadmap. We will start by busting the 2-week notice myth. Next, we will define the boundary war and examine the risks if you walk out without notice. After that, we will share a practical, step-by-step action plan. Then, we will visualize decisions with diagrams, provide copy and paste communication templates, and compare options with a risk matrix. Finally, we will test your knowledge with short quizzes and finish with key takeaways and a wrap-up. 2 weeks. Notice is widely treated as standard, but in most at-will employment situations, it is not a legal requirement. However, contracts, union agreements, or specific policy acknowledgments can create obligations. Consequently, while at-will employees may resign immediately, doing so can create negative reputational outcomes. In short, it is generally a professional courtesy that benefits your references and rehire eligibility. Let us define the boundary war. You set clear availability, yet it is repeatedly ignored. Management continues to post schedules that conflict with your documented constraints. You may even face pressure or retaliation for refusing unreasonable shifts. Stress increases because coordination fails. This raises a crucial question. When is immediate resignation justified? We will answer that, but first we will clarify risks and set a safe decision framework. This content is educational and does not constitute legal advice. Employment laws vary by jurisdiction. Collective bargaining agreements and individual contracts can change obligations. Consult a qualified attorney or your HR department for guidance on your specific situation. With that in mind, let us proceed carefully and pragmatically. Here is a practical plan. First, put your resignation for the problematic role in writing. Second, attach proof of your stated availability and prior communications. Third, escalate to HR or the supervisor's manager if your availability is still ignored, and frame the issue as a scheduling coordination failure, not a performance problem. Fourth, proactively inform the manager of the job you value and ask for their guidance to keep your status secure. Fifth, offer a realistic compromise notice that fits your true availability, such as 3 to 7 days. Sixth, set a clear boundary by stating the final date you can support without harming other commitments. Seventh, prioritize mental health and safety if conditions are unsustainable. Finally, maintain a professional tone in all communications. This decision flow begins by asking whether your schedule repeatedly ignores your availability. If not, give standard notice as a courtesy. If yes, it asks whether you have documented your availability and conflicts. If you have not, the flow directs you to document and then reassess. Next, it checks whether a contract or collective agreement requires notice. If so, you follow the required notice while escalating to HR for protection. If not, it evaluates mental health or safety risk. If risk is high, consider immediate resignation with clear documentation and concurrent HR notification and informing the good manager. If risk is low, offer a shortened notice that matches your true availability. Throughout, HR and the supportive manager are consulted at critical junctures. Use these templates to act quickly and professionally. The first template is a formal resignation for the conflicted role, specifying effective date, documented availability, and limited coverage. The second template escalates to HR or the manager's manager to reframe the issue as a coordination problem. The third template protects the job you value by asking for guidance from your supportive manager. Adjust names, dates, and details before sending. Keep communications concise and factual. This table compares 4 options. Providing 2 full weeks offers lower short-term relief, but the best long-term reputation and rehire prospects. Offering 3 to 7 days often balances relief with reasonable professionalism. Quitting immediately with documentation provides high relief, but yields mixed long-term outcomes, though thorough documentation can mitigate damage. Ghosting without documentation offers immediate relief, but severely harms reputation, rehire eligibility, and references, and tends to burn bridges. This comparison highlights the two-way street. When employers ignore documented availability and continue posting conflicting schedules, the employee's obligation to provide extended notice diminishes. In those cases, shortened notice can be reasonable, especially when supported by documentation, and escalation to HR becomes justified. Throughout, protecting the role you value most should be the priority. This mind map places the employee's needs next to those of the conflicted supervisor, HR, the supportive manager, the organization, and customers. The employee seeks mental health, schedule stability, and future references. The conflicted supervisor is under pressure to fill shifts, which can lead to scheduling errors. HR focuses on compliance and risk mitigation and values documentation. The good manager wants to retain your talent and maintain continuity in their department. The organization aims to protect brand reputation and legal compliance. Customers need service continuity. Recognizing these stakeholders clarifies why professional documentation and escalation help align interests. This timeline shows a compact but professional exit. On day 0, gather documentation and draft your resignation. On day 1, send the resignation, copy HR, and inform your supportive manager. Over days 1 through 3, offer limited coverage, transfer knowledge, and escalate if you remain ignored. By days 3 through 7, finalize handoff, confirm your last day in writing, and request a neutral reference. After exit, update your resume, record outcomes, and maintain contact professionally. Quiz time. The question is whether 2 weeks notice is legally required in most at-will employment situations. Option A says it is always required by law. Option B says it is a professional courtesy unless a contract or collective bargaining agreement says otherwise. Option C says it is required if a manager writes it in a text message. Option D says it is required if HR posts your schedule late. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is that 2 weeks notice is a professional courtesy unless a contract or collective bargaining agreement creates a legal obligation. At-will employment typically allows immediate resignation, though professional consequences should be considered. Second quiz. The question asks what the best next step is if your supervisor keeps ignoring your documented availability. Option A is to stop showing up. Option B is to complain to coworkers. Option C is to escalate to HER or the supervisor's manager with documentation and frame it as a coordination issue. Option D is to accept all shifts to avoid conflict. You may pause the video now to think about the answer. We will reveal the answer next. The correct answer is to escalate to HR or the supervisor's manager with documentation and to frame the problem as a coordination issue. This approach protects your standing, keeps the focus on process fixes, and supports a professional transition. These are the key points. 2 weeks. Notice is typically a courtesy, but contracts can change the rules. Documentation turns a personal dispute into a process problem that HAR can address. When courtesy is not reciprocated, shortened notice may be reasonable. Protect the role you value by keeping that manager informed. Above all, prioritize mental health and safety while maintaining a professional tone. To wrap up, clarify whether you are at will or under a contract or collective agreement. Document your availability and conflicts first. Escalate with documentation and involve HR and the supportive manager. Offer realistic notice and set a firm boundary date. If conditions harm your health or safety, resign with documentation and remain professional throughout. Thank you for watching. If this was helpful, please like, share, and subscribe. In the comments, describe the boundary challenges you have faced and how you handled them. Your insights may help someone else set healthier boundaries.